Welcome to The Explainer. Today, we're unpacking what is literally one of the most massive legal shakeups in modern Indian history. We're looking at the big transition from the colonial-era CRPC to the brand-new BNSS of 2023. But more importantly, we're going to explore exactly what this means for you, your personal liberty, and the fundamental right to bail. Let's get right into it. Okay, we have to start with this baseline constitutional premise. It stems right from Article 21 of the Indian Constitution, which guarantees the right to life and personal liberty. Way back in 1977, the Supreme Court, in the landmark case of State of Rajasthan v. Balchand, gave us this absolutely famous doctrine: bail is the rule, jail is the exception. It's a beautiful ideal. It's totally rooted in the presumption of innocence. The core idea is that a person's liberty just shouldn't be curtailed before a trial, unless it is absolutely unavoidably necessary. But let's be real, there is a totally jarring contrast between that lofty constitutional ideal and what's actually happening on the ground. Just look at the prison population data right now. Nearly 75.8% of inmates are under trials. That means roughly 3 out of every 4 people sitting in a prison cell haven't actually been convicted of the crime they're accused of. They are simply waiting for their trial to conclude. It is a massive, system-wide bottleneck. So, how did we get here? It's kind of like a giant puzzle, really. It's a fascinating push and pull between judicial rulings over the decades and the eventual statutory overhaul. We start with that Balchand principle in 1977. Then we jump to 2014 with the Arnesh Kumar judgment, where the Supreme Court actually had to step in and restrict automatic arrests for offenses carrying less than 7 years of punishment. Moving to 2021 and 2022, the Satender Kumar Antil guidelines further categorized offenses just to try and streamline bail. And finally, all of this judicial maneuvering culminated in the legislative enactment of the BNSS in 2023. Section 1. Shifting to the BNSS. The intervention. Moving away from the old 1973 framework into a more modernized era, what actually changed at a foundational level? Well, believe it or not, the old CRPC never explicitly defined what bail actually was. It's wild, right? It just categorized offenses as bailable or non-bailable. The BNSS finally fixes this by officially defining bail in Section 2(1)(b). Plus, when it comes to anticipatory bail, the old code required this super rigid 7-day prior notice to the public prosecutor. The BNSS rips that requirement right out, giving judges much wider discretion to grant immediate relief if they think it's genuinely warranted. The crucial takeaway here is just how much of the judicial backlog is tied up in these bail disputes. Take a look at this regional data coming out of the High Court of Jharkhand. In 2023, 2024, and the first half of 2025, bail cases consistently made up roughly 50% of all newly instituted cases, literally half the docket. When a high court is spending half its time just deciding whether someone should wait for their trial at home or in a cell, you can see why the system was screaming for reform. Section 2. Key reforms and technology. So, the new code takes a noticeably modern approach to tackling this massive backlog. Under Section 479 of the BNSS, first-time offenders can now seek bail after serving just 1/3 of the maximum sentence for their alleged crime, rather than waiting for the halfway mark. That's a real game-changer, designed to directly reduce prison overcrowding. Plus, the BNSS mandates some serious technological integration. We're talking audio, video, electronic means for hearings, e-filing, and even mandatory forensic video recording of crime scenes for serious offenses to stop evidence tampering in its tracks. Section 3. The under-trial reality. Now, I want you to really focus on this massive number, 434,302. That is the exact number of under-trial prisoners locked up in India as of the 2022 National Crime Records Bureau data. Almost 500,000 human lives just on pause. It is a staggering human cost, and it makes efficient, fair bail administration not just some dry legal issue, but an absolutely critical humanitarian one. But a law is only as good as its implementation. Academic research, like this paper from the International Journal of Law Management and Humanities, points out a major complication in the new law that directly impacts these very under-trials. While the BNSS really aims to be victim-centric and modern, it shifts some absolutely crucial timelines, particularly around police custody, which academics and lawyers are heavily scrutinizing right now. Notice the big shift in timelines here. Under the old CRPC, if the police wanted custody of an accused, they had to take it within the first 15 days immediately following the arrest. Okay, now under the BNSS, actually, they're still limited to 15 days of custody, but the catch is they can now take it in parts, stretching it out over the first 40 to 60 days, depending on the severity of the crime. Critics are arguing that this hanging threat of rolling police custody could easily lead to delayed bail hearings, keeping people detained quicker and longer right at the very start of an investigation. Section 4. The Section 483 confusion. And this brings us to an even more widespread complication regarding mid-level offenses. Section 483 of the BNSS requires courts to impose specific, mandatory bail conditions for offenses, and I'm going to quote the statute exactly here, punishable with imprisonment, which may extend to 7 years or more. These conditions include standard stuff like not tampering with evidence and showing up to court. But that highly specific wording, extend to 7 years or more, well, it led to a massive misinterpretation by trial courts all across the country. Because of that wording, trial courts were reflexively applying these harsh, mandatory conditions to almost everyone, even for mid-level offenses that carried a maximum punishment of exactly 7 years or less. And the real-world consequences? They were totally devastating. I mean, imagine being accused of a minor cheating offense and being ordered to report to a police station every single day. If you work in another city, you lose your job. IT professionals and doctors were forced to surrender their passports, missing international contracts and crucial surgeries. By mechanically applying these conditions, courts were effectively turning bail into a pre-trial punishment. To fix this chaos, the Supreme Court had to step in. In the April 2026 case of Narayan v. State of Madhya Pradesh, the court finally clarified the text. They ruled that the mandatory onerous conditions of Section 483 do not apply to offenses where the maximum punishment is 7 years or less. The Supreme Court forcefully reminded the lower courts that bail conditions must be proportionate and reasoned on a case-by-case basis. They can't just be applied as a blanket rule that ruins careers before a trial even starts. Section 5. Balancing liberty and law. So, how do we balance all of this? To ensure liberty isn't taken lightly moving forward, courts are instructed by Supreme Court guidelines, specifically from the Ender Mohan Goswami case, to follow a strict, gradual process. Step 1. Serve a simple summons. Step 2. If the accused evades the summons, issue a bailable warrant. Step 3. Only if the accused continues to evade should a court resort to a non-bailable warrant. The whole point here is that depriving someone of their freedom should always absolutely be the last resort. But look, bail isn't an unconditional free pass. The justice system definitely retains the full right to cancel bail if an accused proves they are unfit for that liberty. If someone tampers with evidence, tries to flee the country, commits similar heinous crimes while out on bail, or poses a serious threat to law and order, yeah, they will find themselves right back in custody. It is a delicate, careful balance between trusting the individual and protecting society. As we wrap up this explainer, I'll leave you with this provocative thought to consider. Rewriting a colonial law is a monumental achievement for sure, but changing the actual statute is really just step one. How do we change the embedded habits of the institutions and the officers enforcing it? Because if judges act out of risk aversion, and if that old mindset persists, even the best new laws won't clear the backlog or protect the innocent. Thank you so much for joining me on this deep dive into the BNSS and the pendulum of liberty. Keep questioning, keep learning, and I'll see you in the next explainer.